Hello everyone, I'm about to do a civil procedure number 6 video for discovery. Federal Rule 26 requires the mandatory disclosure of information about the pending case to the opposing party. Okay, in California there's no mandatory disclosure of information, though information may be requested. Federal rules, it's mandatory. California, it's not. Federal, 3 types of mandatory disclosures: initial disclosures, expert testimony, and pretrial disclosures. So we have initial, expert, and pretrial. So initial disclosures supply information about disputed facts include identification of those likely to have discoverable information about claim or defense, copies or description of tangible evidence like documents, damages computation, must have a damage computation, and copies of applicable insurance documents. Okay, so these are mandatory disclosures here. Expert testimony, mandatory disclosures of ID of the expert qualifications, and expert's written report. Mandatory. Pre-trial disclosures, before trial, list of all the non-expert witnesses and list of documents of exhibits. All of these are mandatory disclosures within the federal realm. Now, California, as we went back here, California, no mandatory disclosures, okay? Discovery tools, there's depositions, and depositions are under oath of the witness. The deposition of the witness is under oath, it's recorded. Questions can be oral or written, and answers are usually oral. Now the parties. Parties can be deposed. Non-parties can only be deposed by subpoena. They can only be deposed once. If twice or more, they need court's approval. Limits to depositions. In federal court in California, there's no limits at all. California has no limits to their depositions. Federal court limits to depositions there's only 10. They cannot exceed a 7-hour day unless the court approves it. Depositions. Interrogs. Interrogs are questions in writing under oath. Responding party must respond within 30 days. It may not be asked of non-parties. Cannot ask of non-parties for interrogs. Okay, only parties to the case, and they must respond within 30 days. Now, limits, federal limits, no more than 25 questions, unless, of course, the court approves it. No more than 25 questions. California has unlimited form of interrogatories, the max of 35 specific interrogatories. If court permits more, you have to put in a declaration of additional discovery. So a max of 35. Unlimited interrog. So regular interrogatories are unlimited. You can ask as many as you want, have as many as you want. But if there's specific interrogs, only 35. And if you need more, you need to file for a declaration of additional discovery. That's for California. We have requests for admissions. So request another party to admit the truth of any discoverable matter. May not be asked of non-parties. Cannot ask non-parties to do this, just parties to the case. California, maximum of 35 allowed unless you file a court declaration of additional discovery. So 35 max. Request to inspect or produce. Federal, any party can request a party to do so. Non-party needs a subpoena. Make available for review docs, electronic copies, tangible items, or permit entry onto a property. Okay, so these are requests to inspect or produce. In federal court, these are the elements. In California, allows for a party to do, but not the non-party. So up here, the difference is a non-party, you can subpoena them here. California says no subpoena, but then it says maybe a subpoena. So it's kind of up in the air for that. Electronically stored data. I've seen MBEs on this one. Parties meet and discuss and report back to the court. If not reasonably accessible, like if there's too much of a burden of a cost, the court may still order the production but impose cost-sharing measures. Preservation, to preserve certain electronic stored data. Reasonable steps to preserve it if litigation is reasonably foreseeable. So if the plaintiff or defendant foresees they're going to go into litigation about it, they must preserve these electronically stored data items. Or be sanctioned. So if you go delete them on purpose, you're going to be sanctioned, okay? Physical mental exam. I saw one whole essay on this. They must obtain a court order, but the physical, mental condition of the party must be at issue. So they must, if they're going to ask for something, it must be at issue, or else it's irrelevant. It must be at issue for the physical or the mental exam, and good cause for the exam. California allows defendant to have one physical exam if plaintiff condition is at issue. Okay, defendant can ask a plaintiff if it's at issue. Others exams require leave of court. Attorney of the party being examined can attend the examination. That's for California. California limited cases, which we know are 25,000 or less. We had that in our other civil procedure video. Allow each party 35 max total interrogatories. We would know that. Inspection demands and requests combined, a total of 35. So combined is a total of 35 for California limited cases. Inspection demands and requests combined are a total of 35 only. Scope of discovery, this is important. Scope of discovery need not be admissible, must be relevant material though, must be reasonably calculated to lead to discoverable of admissible evidence, okay? Discovery of admissible evidence. Privilege may not. Privilege information is usually not discoverable. In California, the responding party must object. Identification of the document, who's the author, what's the date, all the recipients on the document, and specific privilege applicable. Okay, that's for California. Scope of discovery continued. Attorney work product is generally not discoverable. I've seen this tons of times, not discoverable. A general rule on this is work product is material prepared in anticipation of litigation and is generally not discoverable. Of course, there's an unless, an exception, unless there's a substantial need and the inability to obtain the information through other means is not, you're not capable of doing, excuse me. So it's work product is a material that is prepared in anticipation of litigation. Generally, it's not discoverable unless you have a substantial need. You need to read the facts and use the facts to argue that. Scope of discovery continued. Absolute privilege applies to mental impressions, opinions, conclusions, and legal theories. Federal applies if generated by party or attorney or representative party. California applies if generated by attorney or his agent. Now, the California Constitution recognizes the right to privacy, which is balanced against the need for discovery. So if you get a California essay, you have to go into this right to privacy and argue it with and balance it against the need for the discovery, okay? And then make a decision on that. Now, sanctions for all this. For violations of discovery, there are sanctions may impose, including holding a non-compliant party in contempt, striking pleadings, imposing fees, and ordering a default judgment. Now, mostly tested in this area, I'll tell you, is I've seen the exam ones. Remember the examination, for an examination, or where did I do with that one? For physical or mental exam, it must be at issue. And I remember on this exam, one was at issue and one was not. So it must be at issue in order for them to even ask for it, okay? And work product. The work product was on a couple of exams. Attorney work product, remember, it's generally not discoverable unless you can do, it's a substantial need for it. Okay, substantial need for it. So that's important too. And remember that in order for you to figure out if it's attorney work product, it has to be prepared in anticipation of litigation, and it's really not discoverable unless you can prove substantial need for it based on the facts. And that's it for this lecture. That's lecture number 6. I'll be doing number 7 soon, and number 7 is going to be on disposition of a case without a trial. I'll work on that next. See you guys in my next video.